we're taking in the order. We're taking the Victoria Inn application first and the Coronation Boathouse application at Bantham second. We webcast these meetings live, so if members and any speakers on the applications could make sure they use their microphones, that would be useful. Likewise, if people could turn off or silence their mobile phones, that would be much appreciated. The procedure for the presentation of the applications is as follows. The case officer presents their report. The applicant addresses the meeting. Members will then be able to ask questions of the case officer and the applicant. Then members of the public who have requested to speak in objection to or support of the application will then be invited to do so. And members will be able also to ask questions of those speakers. Once everyone has spoken, the committee will retire to consider their decision, and we will then return and read that out. We're accompanied by a legal advisor in our deliberations who's there solely to clarify questions of law. I'm Simon Rake, I'm the chair of this subcommittee, and I'd now like to invite officers assisting me at the top table and my fellow councillors to introduce themselves.
I'm Councillor Sam Penfold of Marden Little Hempston, and I'm the Deputy Chair.
Hello, my name is Amelia Bolter. I'm Senior Democratic Services Officer and Clerk to this committee. Thank you.
Good morning, my name's Catherine Bone. I'm the Legal Advisor to the Licensing Committee.
Hello, I'm Victor Abbott. I'm a ward member for Ivy Bridge East and a member of this committee.
My name is Naomi Stacey and I'm the Senior Licensing Officer.
I'm Harry Leonis, I'm the Licensing Officer for South Thames.
Thank you very much. We'll now move on to the agenda. Item 1, division of the agenda. I'm not aware of any reason to divide the agenda. Item 2, urgent business. There are no items of Chair's urgent business. Item 3, declarations of interest. In accordance with the Code of Conduct, members are invited to declare any disclosable pecuniary interests, other registrable interests and non-registrable interests, including the nature and extent of those interests that they may have in items to be considered at this meeting. Members, do either of you wish to make such a declaration?
No.
Good, in which case we'll move on to item 4, which is an application to vary the premises licence of the Victoria Inn, 4 Street, Salcombe, TQ8 8BU. Naomi, if I could ask you to present your report, please.
Thank you, Chair. So yes, we're here today to consider the application from St Austell Brewery Company Limited to vary the premises licence of Victoria Inn, 4 Street, Salcombe. The application, in summary, is to amend the licence plan to include an outdoor bar and pizza kitchen within the beer garden. They wish to be able to sell alcohol from this location every day from 10 AM till 9 PM. They also wish to amend the condition under public safety in Annex 2 of the premises licence, which relates to the maximum occupancy of the premises. The current condition states the occupancy of the licensable area must not exceed 90 downstairs and 65 upstairs, and they would like to replace this with a fire risk assessment will be carried out at the premises to determine the safe maximum occupancy to be permitted at the premises, and this assessment will be reviewed regularly and updated accordingly. So a copy of the full application form and the proposed new plan is attached at Appendix A. The premises is currently licensed for the provision of late night refreshment indoors from 11 PM till 12:30, live music, recording music and entertainment of a similar nature indoors from midday till 11 PM, although these activities are superseded by the Live Music Act during these hours, so they could potentially commence at 10 AM. The supply of alcohol for consumption on and off the premises from 10 AM until midnight, and the opening hours of the premises are 10 AM until 12:45 AM. There are also a number of occasions during the year when certain activities can continue for an additional hour as listed on the premises licence under the non-standard timings. and a full copy of the premises licence and the current plan is at Appendix B. The premises is a pub located in the town centre of Salcombe. A location plan is provided at Appendix C. We have taken some photos of the garden, which is included within your additional information. The premises consists of a pub building with a large beer garden at the rear, which is on the same level as the first floor of the pub. And within the beer garden, there's a covered seating area immediately outside the rear door. There are then steps which lead up to a grassed seating area. On the right of that level is where children's play equipment used to be. It's currently got picnic benches there for customers to use. And this area is where it's proposed for the external bar to be. There are then further steps that go higher to more grassed seating areas with picnic benches. As you'll see in the photos, there are residential properties which border the beer garden on all three sides. During the consultation period, we received 20 relevant representations in objection to the application from local residents and from Salcombe Town Council, and copies of the representations are at Appendix D. Some of the issues raised relate to the inclusion of the outdoor bar due to concerns that noise and disturbance will likely increase if it is to be permitted, due to the early start time of 10, leading to potential all-day drinking, the encouragement of more customers to use the garden, and the position of the bar being high up in the garden and close to neighbouring properties. Also of concern is the potential for lighting to be used on the bar, which may be a nuisance to neighbours. The concerns raised in relation to the amendment to the occupancy condition include the fear that this will result in an increase in the number of customers being able to use the pub and the beer garden, and therefore leading to more noise and the potential for antisocial behaviour. Any information contained in the representations which is not relevant to the promotion of the 4 licensing objectives cannot be taken into consideration. As mentioned in my report, as the applicant is not applying to sell hot food after 11 p.m, that activity is not licensable for our purposes. Therefore, any concerns that relate directly to the smell of cooking, food, or the potential exacerbation of the seagull problem due to people eating food outside cannot be considered through our process. Some of the representations make reference to the addition of a pergola within the garden. While this was considered as part of a recent planning application, permission for this is not required under the Licensing Act 2003 and is therefore not being considered as part of our process. Since the publication of the report, we've received further information from some of those who've made an objection. That has been circulated to the applicant and to the licensing subcommittee for their consideration, and including within this are some photographs and videos taken of the beer garden from a neighbouring property. I can confirm that no representations have been received from any of the responsible authorities who were consulted on this application, including Environmental Health and the police. So as always, when considering an application to vary a premises licence, only issues which directly relate to the reason for the variation, in this case the addition of an external bar and the amendment to the occupancy condition, and how they relate to the promotion of the 4 licensing objectives can be taken into consideration. And as a reminder, the 4 licensing objectives are the prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. Please let me know if you have any questions. Thank you.
Thank you, Naomi. Members, do you have any questions?
So when there's a permission to have music whenever there's food being served, is that statement correct?
The permission to have music under the Live Music Act relates to areas where alcohol can be consumed on the premises rather than food. So as this premises can sell alcohol for consumption on the premises, and the areas that are designated for consumption include the beer garden, as well as obviously the internal building, those areas are covered by the Live Music Act, and they could have music in those areas between 10 a.m. and 11 p.m. because they are the hours they're licensed for the sale of alcohol. The Live Music Act never applies before 8 a.m, but it only relates to when alcohol is being sold. However, in addition to that, they also have music specified on their premises licence from the Live Music Act coming in, which is from midday until 11 p.m. And then, as I mentioned, I don't think the non-standard timings actually apply to entertainment in this circumstance. So it would never go past 11 p.m. for this specific premises.
So there's a drinking up time often associated with 15 minutes, half an hour. Would the music end at 11, not at the end of the drinking up time?
Yes, so music for the purpose of regulated entertainment, so for the purpose of providing entertainment for people, would need to finish at 11. Background music isn't licensable, so the type of music you would have, that you could have a conversation over, that may well be playing until the premises closes, but that's not something we would license.
Thank you, Councillor Abbott. Councillor Penfold.
I'm interested in the occupancy, the additional occupancy. Is it usual to apply for an additional licence or a licence without having some understanding of what the occupancy number would be?
Yes, it's actually quite unusual for there to be a set capacity on a premises licence due to the fact that it is already covered by other legislation, fire regulations specifically. Our general guidance and the guidance under Section 182, which is our national guidance under the Licensing Act, always suggests that we do not duplicate other regulations and other legislation, especially when there's the potential for it to contradict one another, which I believe that is correct in this case. They have now undertaken a fire risk assessment, which I believe is slightly different to the numbers that we've got specified on the premises licence. They're actually in contradiction. So when the premises licence was granted, those figures would have been put forward by the applicant. That is their option. They can put forward a capacity and we will then put that on the licence if they wish. However, it's not a requirement that they have to put a capacity when they apply for a premises licence. This licence has been in effect since 2005 when the Act came in. No amendments or changes to the licence have occurred since then. So there's not been any previous opportunity to amend that condition or any of the older conditions on there. I've got some of the guidance I can read out from in relation to safe capacities, and it does say safe capacity should only be imposed where appropriate for the promotion of public safety or the prevention of disorder on relevant premises. For example, if capacity has been imposed through other legislation, it would be inappropriate to reproduce it in a premises licence. So it's already on there because that was what was issued back in 2005, but they've decided in this circumstance to kind of update that condition and make it relevant to a current fire risk assessment. And obviously regulations to do with safe capacities do change at different times, and how the fire risk is assessed might change. So I presume it's to give them flexibility. I think that's probably the purpose of it. So it's quite normal for us not to have a capacity.
Okay, right, that's good. Okay, I understand that. So, but surely capacity is going to be reflective on the amount of noise and disturbance in that.
Essentially, yeah.
So are there no figures that we can have now?
You can. There's nothing to prevent you from placing a capacity on a premises licence as the licensing subcommittee. That and the authority, you have the power to do that. You would obviously have to give good reasons for those figures, and if you've got that justification, and that's perfectly legal to do.
Okay, right. So let me see if I can get this straight. Do you have some figures already, or you have some idea of figures already that of the number of people that would be able to be in that space?
They have recently undertaken a fire risk assessment, so that's based on the fire regulations. That's what we would be guided by, because we are not the experts on fire regulations or safe capacities, and it's all to do with being able to get the customers obviously out safely in an emergency, and that's what those numbers are set with.
So in the presentation, we're going to be given.
I presume they will. Yes.
I will explain it all.
Okay, that's fine. Okay, all right. Thank you.
Do you have anything else, Councillor Penfold?
Not at the moment, no.
Thank you. In which case, I'd like to invite the applicant to speak. Perhaps you'd do us the favour of beginning by introducing yourselves. Let us know who we're talking to.
Can you hear me now? Thank you. My name's Jonathan Smith. I'm a solicitor from Poppleston Allen, and I represent St Austell Brewery, who are the applicants. I'll let my colleagues introduce themselves to my left and right.
I'm Danielle Birkinshaw and I am the Designated Premises Supervisor for the Victoria Inn.
And General Manager.
And General Manager.
And my name is Gareth James. I'm the Operations Director for St Austell Brewery, looking after the managed estate.
Councillors, could I just clarify two things before I start? So just on your procedure, you mentioned 10 minutes, unless there is some leeway from yourself that I have to limit my presentation to you. And obviously, Councillor Penfold, you've asked a number of questions about capacity, which I can go into in more detail, and also about the Live Music Act. Can I have some leeway on the 10 minutes? Obviously, my friend will
We
have
don't
the same leeway.
we don't enforce it particularly strictly. If you need to run over, then that's.
I'm sure I won't run over.
Although I'd caution you that 10 minutes is generally enough for most things. But
just the second query is, do we have a chance to sum up at the end after questions, or do you not have a summing up procedure at the end?
We don't. So yeah.
10 minutes is going to be very tricky then, councillors. So, yes, my name is Jonathan Smith. I represent St Austell Brewery. It's a variation application. If I could perhaps answer those two questions that were raised, sort of outside my 10 minutes, just on the Live Music Act. Yes, so we're actually allowed to sell alcohol within the beer garden until the same hours that we can sell alcohol actually on the premises licence, which is midnight. But the Live Music Act by law allows us to provide recorded and live music in the beer garden from the start time for alcohol, which would be 10 o'clock to 11 o'clock at night. So we are permitted by a general permission under the Live Music Act 2012 to provide that entertainment. As an aside, we don't, but we could do. But the beer garden is already licensed. We're not asking for the whole beer garden to be licensed. We can actually sell alcohol anywhere within the beer garden at the moment because the whole beer garden is licensed. And just on the other point, yes, the safe capacity, I will deal with the figures, Councillor Penfold, for you. And yes, I was quite right. There is a national guidance at paragraph 8.13, which says if something is controlled by another piece of legislation, then it's inappropriate to impose a condition through the Licensing Act. But actually, your own policy says at paragraph 3.6.3 that the licensing authority recognises that the regulatory reform fire safety order replaced the previous fire safety legislation. Accordingly, the authority will not seek to impose fire safety conditions on a licence. So that's in your own policy, actually, councillors. The reason why I think the capacity was on there is this would have been a licence converted in 2005 before this fire safety order, before the requirement for a fire risk assessment came about. So I think that's why there is a capacity on the licence now. But I'll give you some figures anyway, councillors, because I know you need to know what the safe capacity is. So anyway, I'll start with 10 minutes. That was a little explanation. Thank you. So it's a variation. Naomi's explained it. Thank you. And the variation you can see on page 12 of your agenda pack. I would like to make one amendment to the application, and that's in light of a couple of the representations, which we take the point, is we'd ask for alcohol sales to start at 10 a.m. We'll amend that, with your leave, councillors, to noon, so it would start at 12 o'clock. I think a couple of the residential objections say, why do you need it from 10 a.m? The pub opens at 11 o'clock, but food service doesn't start till noon. So the first application, or first aspect, is to have your permission to permit the pizza servery kitchen and also the bar in the beer garden, and also to amend the occupancy condition with a risk assessment. Just to be clear, there's no extension to hours that we currently have. There's no request for music anywhere within the pub. We do have inside, we can have it to 11 o'clock, and then the Live Music Act, as I've said, allows us to have it outside, but we're not requesting music. And there's no extension to sell alcohol within the beer garden because the whole of the beer garden is licensed anyway. What we're asking your leave for today is for the bar servery and the pizza kitchen within that building, and also the change to occupancy. So the capacity at the moment on the licence, you'll have seen, councillors, is 90 downstairs and 65 upstairs, and it doesn't mention at all the beer garden. Our fire risk assessment is 100 inside in total. So that's where the confusion immediately arises. We've actually got on the licence 90 downstairs, 65 upstairs, but because of the fire exit width inside, our safe capacity to get people out is 100. And that's why, and this is why the guidance says it's not good to have capacities on licence which may contradict your fire risk assessment. For the beer garden, likewise, because of the fire exit widths, it's also a maximum people of 100 within the beer garden. So that is the maximum figure councillors in the beer garden. Why have we asked to replace that? I think we've already dealt with that, and I've also explained the national guidance. It's inappropriate to have a capacity if it's imposed for another piece of legislation. There can be conflicts in it, Councillor Penfold, and also your own policy suggests that you shouldn't be having conditions anyway where they're covered by the fire safety order. The fire service was obviously served with the application, as was environmental health and the police, and there were no representations from any of those parties in respect of that aspect. So you've got the bar and the pizza kitchen. That is for the sale of hot food and also for the sale of alcohol. There is no request, and Naomi's mentioned this, to sell hot food after 11 o'clock from that pizza servery, bar servery. So we don't need late night refreshment outdoors because hot food and drink is only licensable after 11 p.m. It's in a fixed position, so we do need your approval. It's obviously an extra bar servery point where you can buy alcohol from it. It's in a fixed position. Why would we like it? Now, we have pressure on the bars inside. If you've been in the Victoria, it can be very busy in the bars there. It's food taken directly outside at the moment. It has to be taken upstairs. It can be cold by the time it reaches the top. We're very much increasing the food offering. We don't have pizzas at the moment, so this will be something new. Since Danielle's been there, our food and drink offering is now 50% food, 50% wet, so that includes alcohol and non-alcoholic drinks. And I think food has gone up 40% and drink has gone down 55%. So we're very much looking more on the food side of things. We need to keep up with the times. We need to be innovative. We need to make sure the beer garden is an attractive place and that people will want to eat something there. I'm sure you've seen in the press 80 pubs a day closing, 80 pubs a month closing at the beginning of the year. This is part of a general refurbishment of the beer garden that St Austell Brewery are undertaking since it came back to the managed estate in 2019, and does include the new pergola area at the far end. But as Naomi's explained, there's no licensable activities being carried out there. We don't need permission to put that patio up there. There's already planning in place. And of course, since COVID, outdoor bars are quite popular. I think, indeed, I think the council actually permitted the pub to use somewhere over in a car park on the other side of the road of the Victoria when COVID hit and we were drinking and eating outside. And of course, let's hope it never happens again, but we would have an operation immediately built in that we could continue to serve outdoors. There are still reticence from some people going indoors, but it does allow us that should we be in the unfortunate circumstances in the future. So how does it work? It's you go up to the hatch, you order your pizza, you get given one of those buzzers, and when your pizza's ready, it buzzes and you go and get your pizza. Alcohol can be ordered either at the bar, the outdoor bar, or alternatively as a QR code on tables, or you could go to the bar service and actually enjoy bar service. The actual the bar itself is staffed by 2 members of staff. So you've got one who's looking after the bar, one who's looking after the pizzas. To answer the seagull question, although it's not relevant, the member who's looking at those members of staff will also be responsible for cleaning the beer garden. We also have 2 members of staff who work outside as well, in addition to those in the outdoor areas serving food, and they will also collect plates and dirties. CCTV will cover the bar survey from the outside. Sorry, from the inside pointing outside. We'll have window panels, a window panel at the back and also in the door and obviously at the front. So supervision will be a lot better. We'll actually have 2 people there supervising the beer garden and the rear of the beer garden, which we don't currently have. There's no music planned to be out there. We could have it, but we're not having any music. We've never had any music outside, councillors, whether it be background or louder than background. Pizza is cooked in a conventional oven with, if you like, one of those vents that you've probably got in your house that goes outside. It's not what you would regard as a typical extractor fan. We do have to agree the extraction system, though, with the local planning authority as part of the planning grant. There will be festoon lighting, and I know that will, I'm sure, form part of the representation that's put to you, which will go over a umbrella, a big umbrella, which is outside the pizza and bar servery. However, again, we must agree a lighting strategy plan with the local planners before we can put the lighting up. So that has to be agreed, obviously, to make sure it doesn't cause disturbance. So that's the application. In terms of the representations you've received, I can probably skip through some of these now. Increased noise levels from rowdy behaviour and it being brought further up the garden is concerned. Well, of course, The area at the top, as I said, as Naomi's confirmed, we don't need permission for that. So it's been concreted with a pergola over it. We don't need licensing permission for that. We have planning for it. There's some concerns over noise problems in now that you've got now. We've never had a noise complaint in the last 3 years at St Austell Brewery since it's been undermanaged. Environmental health, and I've spoken to Naomi about this, environmental health, I believe, has never mentioned any complaints to Naomi. There's no representation from environmental health today. There's been no complaint made to Danielle other than by a Wendy Fitzsimmons. Don't know if she's here today, about a security light that was on top of the pergola and was coming on and going into her bedroom, and you disconnected that through the electrician. The occupancy increase is a concern. You've heard how many now that we're looking at, which is 100 through the fire risk assessment. We'll find it hard to get any more than 100 in councils because if you know the pub, there's one side entrance out of it. You can't actually use the other side entrance because it's a council. It's the council's gate at the bottom. It's a very lovely gate which is owned by the council, and it's too low to get anybody out of anyway. So we only have one fire exit route. There's concern that music should be played. Well, it won't be played, councillors. We won't be playing music. We don't play music. We could. We didn't show the Euros that somebody's referred to. The pub is actually licensed to 12 o'clock with drinking up time to 12:45. We typically operate to 11, closing at 11:30 at the latest. So we don't push the boundaries by any means here, councillors, but you're not here to review what we've currently got. We're not seeking later hours. Increased light pollution. The lights will go off at 9 p.m, which is when we've asked for the bar to be licensed until. And as I said, we've had to agree this this light strategy with the planners. Concerns that the garden will be used later into the evening. Well, again, the bar servery pizza will have to close at 9 o'clock. Naomi's dealt with the seagulls and the smell from extraction fans, so I won't go through that. There's some reference to structural concerns, which I believe is, again, about the pergola at the top and the fact that it may stop drainage and it's not going to be permeable stone. The drainage officer, as part of the planning, looked at that, but we don't require your approval to that. And then finally, I think an emotive subject has been the removal of the children's play area. This was a private play area operated by the pub. I know that Salcombe Town Council will say something about this. It has been removed, councils. I know there is concern about it. So obviously it's our own area. We can remove it if we wish to do so. There is another play area, I think, at the back of Courtenay Street, about 0.2 miles away. So there is another play area very close. So to sum up, I've told you what the variation involves. I would ask you to stress, and I'm sure your legal advisor will tell you, that this is not a review of our current licence. So you're not reviewing to say, there's festoon lighting on the pictures we've seen, or people are talking underneath the tented structure we've got there. Any conditions or action you take as a result of today is in relation to the representations made about the likely effect of the grant of this application. So if you're managed to impose any restrictive conditions, it should be at times this bar is open for the sale of that. Is that my 10 minutes? Is it? I'm nearly finished as well. I did have that extra bit at the start. So it is about the effect that this variation application will have on the licensing objectives. You're not here to look at what we're currently doing. As I've said, we've had no complaints, no issues. I have given your solicitor, and I think also my colleagues had one as well, who represents the objectors, a copy of a case of Manchester City Council and Taylor, which makes it quite clear in obiter, which is the observation of the judge in that case in the High Court, that a variation should never be treated as a review. There is a mechanism for review. The light and noise pollution issues, as I said, we've had no complaints at all. Until we actually issued this application, we'd had no videos or photos, we'd had no communication from residents about lighting or about any noise from the beer garden. And to stress that we did have one complaint other than from Wendy Fitzsimmons about the security light, and that was turned off. There's no environmental health officer representation, and we will only be operating that area till 9 o'clock. I will probably have the chance, I'm sure, to address you on the photographs and videos that my friend will refer to. But what I would say is this application has been now advertised for 2 months. We have a number of people who garden overlook the beer garden here, and that's what they have produced. I'm not sure what the children stood on tables signifies, and I'm sure we'll be told. Your policy, councillors, refers to a balance between residential interest and tourism and business. And also it talks about the fire safety order. I would ask you to have a look at paragraph 3.6.3 about fire safety order. And then finally, your national guidance, safe capacities don't need to be on a licence where they're imposed. It's inappropriate to put them on where there could be confusion. And you should be guided by paragraphs 9.12 and 9.15 of your guidance, national guidance, which says that your advice about crime and disorder, and in particular here advice about public nuisance, would come from your environmental health officer, and therefore it should weigh in our favour that there has been no representation made by environmental health. They have no record of any complaints as far as we're aware through Naomi. You're considering what is the risk of the licensing objectives.
Can I ask you to bring this fairly swiftly to a close? Okay.
We run a good ship. We don't push the boundaries. We're a very good track record here. We've had no complaints, councillors. It is restricted to 9 p.m. Please bear in mind that after this pizza closes, we've been operating this beer garden and these premises to 11 o'clock for many years and could go to 12 o'clock without issue. So there's no reason to suspect that operating a bar pizza servery to 9 o'clock would cause any public nuisance.
Thank you. So just to clarify, the beer garden is already licensed. It's the fact that it's a fixed point of sale that requires this license. Okay.
Yeah, so under the plan regulations, if you've got a fixed structure which could impede access egress, then it needs to be shown on the plan, and it's also selling alcohol out of there, so it's only appropriate. If we'd put a bar servery in the beer garden there, I don't think residents would have been too happy about it, and I would imagine would have been on the phone to Naomi. So that's right, sir.
And you say that the lighting on the new bar will be turned off at 9 p.m. But will presumably other lights will remain on in the garden as they do currently?
Yes, so the situation, which we're not here to review, the current situation, they will remain on as they are now.
And just on the fact that you've not so far been aware of, or there've been no complaints. I mean, it's possible that, I mean, the straw that breaks the camel's back, that the concern is that any increase, that your neighbours are tolerant and aware of the fact that they've purchased or live in a house that's next door to a pub, and that comes just like living in a house next door to a church, comes with certain, but that any increase would push it beyond tolerable bounds. Do you see that as a valid concern?
I would if we were looking to increase the hours, but we're looking to license a pizza and a bar servery only till 9 o'clock. We've got another 3 hours, 45 minutes trade after that, which we can legitimately carry on now. And we could have food in the beer garden actually bought from inside and taken outside. So no, I don't, councillors. I suspect it will be busier with the pizza and bar servery there. But I do stress that's only until 9 o'clock. If we were asking for something till 11, 12 o'clock, yes, but this is going to finish early. And that was a recommendation which we received from the planners and agreed to.
Thank you. Councillors, Councillor Penfold.
You made a good point about, well, we're not looking retrospectively, and there's been no complaints up to this point. But then you talk about, well, there's been no complaints about this up to this point, and make it as a positive thing to the variation that you're being asked for. So it's a bit wanting to have everything, isn't it?
Well, one of the guidelines is that when you're considering a variation, you do look at the track record of the premises, and you should do. Because if we had complaints up to 11 o'clock, I can understand that you might have greater concerns. That is one of the guides that you should have a look at.
From you, Councillor Penfold.
Yeah, so you did talk about the fact that you can actually take food out in the garden and alcohol out in the garden now. So what do you see as the benefit of having this in the garden as opposed to what you have now?
Yes, we could set up a barbecue in the garden at the moment. We could set up a mobile gin bar or a Prosecco bar that's not fixed. We could do that quite legally at the moment because the whole area is licensed. We would rather have a pizza offering, which is something we don't currently do. It's a fixed point because you've also got beer taps that you can have actually in the bar servery, which otherwise it would probably be bottles, Councillor Penfold. And also, obviously, you've got a structure which is better for supervision. So you've actually got a structure there which has got windows in all three sides, so you can have a look all the way around. And it's, I guess it's more of a feature, but we could, if we wanted to, as I said, do this in a mobile way, councillors, but we'd rather do it from a fixed structure. We do currently have 10 of these. St Austell have been pushing these out, particularly after COVID. We do now have 10 outside bars elsewhere in the estate.
Are you done, Councillor Penfold?
Yes, I say so.
Okay. In which case, thank you very much. And I would now like to invite Mr. Darcy, who is speaking on behalf of neighbouring residents, as I understand it.
Yes, Chair. Good morning. Chair, before I commence, a similar query regarding housekeeping. I'm speaking on behalf of a number of residents who've asked me to do so. There are a number of residents here also, subject to your better judgment, and if you're content with your leave, rather, some indulgence on the time might be a better use of the committee's time today, rather than hearing from all of the members individually, or rather the representations individually, 10 minutes at a time. I don't plan to go on for very long, but I might go over that 10-minute buffer.
I'm happy to grant you the similar flexibility that I granted the applicant, and we'll see how it goes thereafter.
Grateful. Thank you. Chair, councillors, as introduced, I'm a barrister instructed on behalf of those who've made representations in respect of this application. I'm grateful for the update from the applicant this morning. We didn't have that information until this morning, and I'm sure you, Chair, and your fellow councillors are grateful for that additional information, particularly about the numbers, and I'll come to that in a moment. That may affect my flow as I've made some amendments, so I hope you will bear with me. The first issue, before I talk to the licensing objectives, which have been set out in the some 20 representations that you've had before you, together with the photographs and videos, and I trust, Chair, you've had an opportunity to consider those before convening today. I'm grateful. We may want to play some of those, again with your leave, or you may wish to review those when you retire to consider this matter. But the first issue, I respectfully submit that this committee will have to grapple with, and with the assistance of your licensing officer and your learned legal advisor, is to whether this application can in fact be considered under Section 34. Section 34 provides for applications to vary, but by virtue of Section 35, it sets out quite clearly that in doing so under the prescribed manner under Section 34, there are three aspects that you cannot use Section 4 to vary. One being to change designated premises supervisor, the second being to extend the time of the license that it has effect for, and third, which I'm drawing your attention to, is to vary substantially the premises that it relates to. Statutory guidance, my friend has drawn your attention to that this morning, set out circumstances, and you're a very experienced chair with your members, of what would fall into the category of a minor alteration, a minor amendment, which would satisfy the requirements of Section 34 in terms of a minor variation. There are many examples set out in your own policy in respect of that. My submission to you is, on this point, Section 34 cannot be used to vary substantially the premises that the licence relates to. And the construction and introduction of a new service point, a new point of sale of alcohol, in my submission, is not and should not be treated as a minor variation. That's quite a significant variation. In fact, in your own notes and guidance that accompanies the application which the applicant has filed at page 10 of the papers, It says in bold, this application cannot be used to vary the licence so as to extend the period which the licence has effect, or to vary substantially the premises to which it relates. If you wish to make that type of change to the premises licence, you should make a new premises application under Section 17 of the Act. Now, your learned legal advisor will no doubt discuss this with you when you retire. There is no hard and fast definition as to what is defined as vary substantially. It's not defined in the Licensing Act anyway. It's not defined properly in statutory guidance or in your own licensing policy. We only have examples of what would be considered a minor variation. Chair, you and your panel members are experienced in planning and the planning regime in respect to these matters, and I appreciate we're talking about licensing here today, but you will know the classic test for the validity of an amendment under the planning application is that the result must not be substantially different from the development applied for, or a reasonable judgment would be made in considering whether there's a significant difference or not. That's what happens under planning. When you consider other neighbouring local authority licensing policies, and I looked at both Plymouth and Torbay, there's a common theme in their guidance as to what applicants should do when they're planning to make significant changes. And they say if you're changing the nature of your business, you will need to apply for a new premises licence. That includes adding the sale by retail of alcohol. Presumably, Chair, therefore, I would advance that it's intended that the holders of premises licences should be required to submit applications for new premises licences where substantial changes are being contemplated. When you look at this application, it is the installation of a new bar, a new point of service, away from the main bar. We've heard it in the licensed beer garden, but we're talking about the introduction of a new structure, a new point of sale. So, on that basis alone, Chair, I would respectfully submit to you and your colleagues that the application should be refused on the basis that it can't be made under Section 34. It should in fact be made under Section 17. That's the appropriate mechanism to vary substantially the licence that the premises applies to. That's a matter that I appreciate, Chair, you will take legal advice on and you will be guided by your learned legal advisor. Turning to the plans and allowing for the new information today, we've heard about the bar and the pizzeria. And I invite you, Chair, when you do retire, or you may wish to do that now with the applicant after my representations, to zoom in on that bar and pizza servery, because I appreciate I'm not a Luddite. I can use PDFs, but I struggled to visualize how this new pizzeria would operate in this bar floor plan. It wasn't clear to me how large this pizzeria oven and the provisions for the oven and waste management and the rest of the bar servery all fit in. And I appreciate architects are far more clever than I in terms of utilising and maximising space. But it wasn't clear to me, the more I zoomed in, on how this pizzeria was going to operate within this new licensed servery. I'm grateful very much to my friend who's advised that there will be now 2 staff manning the new bar at all times whilst it's trading, and there will be, as I understand it, and forgive me if my notes don't reflect what's been advanced, there will be 2 floor staff, so that's 4 staff whilst this area is trading. And there was also talk of 2 supervising. Again, that's 6 staff, but if that's my misinterpretation of the figures, I'm sure I'll be corrected when I finish my representations, and that can be confirmed. But it's unclear from the papers before the committee, and you, Chair, will want to be satisfied exactly what kind of supervision, save for the windows we've heard of, will be going on in an area that we now understand the capacity being sought to be permitted is 100 people. So if we run with that scenario, there's 100 people in the garden and there's 100 people inside the main pub, that's 200 people. In terms of the management of that capacity, because you are being asked to dispense with the previous Annex 2 condition, it's not clear to me, and it's certainly not clear to those who instruct me in the representations here today, as to how that is going to be properly managed. So clarification will be required, I'm sure. I note what the applicant says about public health, environmental health, licensing, police, and I assume fire is thrown into that also, in terms of they have been notified and there have been no objections or representations made. That's not information that we had before today, but I'm grateful for that update. But turning back to the structure, logistics and management of that new bar, Chair, you will be very much aware, and my friend has drawn your attention to the Section 182 guidance updated in December of 2023, particularly Chapter 9, where licensing committees, officers should consider decisions with their planning counterparts prior to determination, with the aim of agreeing mutually acceptable operating hours and scheme designs. And that will be crucial to this new bar in the beer garden. Your own licensing policy, which your attention has been drawn to, I invite you to also consider sections 5.14 in terms of the measures being proposed by the applicant, and also 5.15 in terms of the planning considerations I've alluded to, particularly dealing with antisocial behaviour, disorder, littering, fouling, noise, and the capacity and infrastructure. Again, that's in your own licensing policy at 5.1.5. You will be very familiar, Chair, with 5.1.8 of your policy. The key purpose is not to respond to crime and disorder, but very much to make an informed assessment of the risk of such things occurring in the licence. That's what your policy says. There has been no, I had put meaningful, it appears, or certainly I'm instructed, there's been no consultation whatsoever with the residents who live around this beer garden. And those have been set out in the 20 letters of representation that have been served on this committee. There's been no consultation at all, which is quite staggering given the size of the applicant. It's not a one-man pub-owned company. St Austell own, I think, in excess of 180 pubs in the southwest alone. It does seem quite bizarre that they haven't taken the time to consult with the residents. Had they done so, perhaps some meaningful conditions might have been agreed before this matter came to you today. In terms of extending the sale of alcohol, and I'm conscious I will try and canter through my notes, in terms of extending it, we now hear that it'll be commencing at 12 until 9, if I understand that correctly, rather than 10. Even that, in my submission, still is unreasonable. The bar doesn't magically get prepared at 12 o'clock. The shutters are pulled up and ready to trade. There's the preparation of the bar area, moving of barrels, stocking it up, getting the staff in situ. So if it was to start at 10, that would have been completely unreasonable, because that would have been at least an hour or two before trading commences. Starting at 12, that still pushes that noise for the residents to endure before 12 o'clock. It doesn't magically arrive. And contrary to that, if it's perhaps suggested that, well, no, we set up the night before, so all you have to do is flick the switch and light up. Well, that would concern you greatly, Chair, because if it's due to finish at 9, and they have to get the 100 people out of the garden in a very orderly fashion, these people who have had their fill of drink, they will all leave singly file. If the bar is then going to be set up that night for the following morning, we'll have skips being emptied, bottles chinking, kegs being moved after 9 o'clock, so that noise will continue into the evening. So you can't have it both ways. It's either set up early in the morning or set up the night before. In any event, the residents who are already enduring significant noise and antisocial behaviour as a result of the patrons in the premises will have to endure that even more. You have read representations as to how the children, again, a licensing objective, protection of children, public nuisance, that isn't restricted to just those within the red line. Children reside in the properties around the premises, and children visit those properties. It's not just restricted to people within the red line of the licensed premises. And you've heard about lighting pollution, antisocial behaviour, attracting pests, cigarette smoke. There's evidence of all of that in the photographs that you've seen, and I invite you to consider that again when you retire. The festoon lighting it's been described as, and you would have seen the photographs and the videos, and again invite you to refresh your memory. When I saw that, I called that flood lighting. It's not festoon at all. It's bright, and we've heard today that the lights will be switched off in the bar, but the lights which are being classed as festoon lighting on the stretch tent, they're like floodlights. You could play football or tennis in the evening underneath those, and neighbours are already enduring those now. My submission is that's going to get worse with the imposition of a new bar in the beer garden. And I've dealt with the closing time of 9 o'clock. The revelry will continue, and that's going to be an issue for public nuisance, and you have your guidance on that. You must consider that, and that's reinstated in terms of within your own licensing policy. If I may just turn to the videos and the...
Before you do, how much longer do you think?
I only have about 5 minutes. I'll make it 4. Thank you, Chair.
3.5 would be good.
Oh, excellent. I invite you to look at those videos again. We shan't play it now because we're restricted on time. But when you do, you will notice the timeline that's been provided. And some of these videos are as late as 11:55 p.m. And that's what's going on now. These issues are going to be exacerbated significantly with the imposition of a new licensed point of sale. And similarly with the photographs that have been provided, and I do urge you to review those, you will see antisocial behaviour in the photographs. There's one individual in a tree. There's children on top of, not sat at the table, not being supervised in at least 2 photos that I've seen. So whilst the applicant will obviously try and present a very well managed premises, and no criticism whatsoever of the manager who's here today, it's the representative's view is that there has been no proper thought as to what the operating procedure will be like if you are minded to grant this new premises, subject to you actually being able to do so. As I set out under section 34, it should be a section 17, and you'll take advice on that. That's been dealt with, forgive me. And turning finally to the numbers, again, a substantial variation. You're removing a condition that this committee, regardless of when it put it in place, how long it's been there, and things have moved on and times have changed, this committee thought it was necessary and reasonable and more important to put those numbers in place. And you're being asked now to remove those subject to the risk assessment that's been presented this morning. That will have to feature into your decision making. And finally, Chair, you will know that there have been representations and enforcement issues in terms of the planning aspect of this, where officers had to attend the premises in respect of the planning consent for the bar itself and the work. And you will hear from the Town Council as to their view in terms of the removal of the children amenity and their view as to the application. in summary, Chair, and I'm grateful for the additional time that you've afforded me, but I thought that was better than hearing from many people with their 10-minute slots. I invite you to reject the application at the first instance on whether it can be dealt with under Section 34. In the alternative, I invite you to reject the application because there are insufficient measures in place to mitigate the many representations which affect the 4 licensing conditions that you will have at the forefront of your mind. The representatives do instruct me to remind St Austell Brewery and all members here today, they're not against the pub at all, keen to see the premises continue. We all enjoy a drink, and it's right that we should have these hostilleries to avail of, and they're very supportive of the pub. It's just disappointing that they haven't taken the approach to involve them in the application until we're here today. Unless I can assist you any further, Chair.
Members may have questions, but thank you. I have questions indeed. Presumably, turning to your first point, you take no issue with the applicant's statement that they could have a mobile Prosecco vending cart in the beer garden as things stand under their existing licence.
I take no issue with that. That's absolutely accurate.
I'm just trying to quantify your point about whether this can be dealt with under Section 34, whether...
Well, they're entitled to do that under their existing licence.
Yes.
It's a mobile premises, so they can stick a barbecue in the corner, a gin bar, as the applicant set out. This is very different, and I hope you've made the distinction, Chair, that that's incredibly different to a bar being put in the corner or minor variations in terms of moving things. This is the imposition of a brand new structure.
Well, as you suggested, we will take further advice on that. My understanding of the applicant's presentation in terms of the numbers of staff was that there was 2 staff in the bar and 2 staff, ambulant staff, but the supervision was coming from the 2 staff within the bar. I mean, a simple nod will do, if that was...
There's 2 in the bar, and there was, or this bar pizza, there's 2 also who serve outside, and it would be from all 4, but predominantly it would be the 2 who were in the actual bar servery.
Thank you. Councillor Handfold.
Can I just go back to the staffing thing? That's their decision, is it not, about what they do with staffing? It's not down to us as licensors, is that right?
Usually, yes. Obviously, there's nothing to prevent a condition relating to the number of staff in a particular area. Occasionally, we may have that on a licence, but it's not a usual condition that we would have on every licence, but it's an option.
Chair, may I answer Councillor Penfold's question also? In terms of whether it's a condition for it, you're absolutely right. But the licensing objectives at the forefront of your mind today, councillors, is ensuring public safety, prevention of public nuisance, and protection of children from harm, and the 4th being prevention of crime and disorder. And proper supervision and management of an area where people are consuming alcohol is very much down to the management of the premises. And if there are 2 staff working the bar, serving 100 people, and 2 staff delivering to tables, there's no security staff being mentioned here whatsoever. I'm not convinced, and it's a matter for you. You will have to be convinced that that's appropriate. It's not for you to determine that, but it'll be a factor when you're considering the 4 licensing objectives.
But just for clarity, this is this is over and above the current level. I mean, other than people picking up glasses, this is 4 extra people in a garden that could already have an unlimited number of people in it, as I understand.
I understand that the garden is staffed or attended to by members of staff who work in the pub. What this is concerned with today is a new structure, a new service point with 100 additional guests. At the moment, there might be 10 guests in the garden being served from the main bar, so the requirement for staff to go out there might be much less than when there's 100.
So do I get a chance just to clarify one point which keeps getting raised over and over again? Can I just clarify one thing? Sorry.
Tell me which point it is you wish to
It's this
clarify.
additional 100 people. That,
Yeah.
is it,
I think I've got that clear in my mind.
No,
I
can
think.
you
Okay,
do
all
that?
right then.
I think this.
so it is important. First of all, the risk assessment actually reduces our internal capacity from 155 to 100. There is no capacity stipulated for the beer garden. This is not an extra 100 people. I would like the opportunity to just address some other points that have been raised, such as is this a new application? But that was just for now, because my friend keeps mentioning this additional 100 people.
Thank you. Okay. Councillor Penfold.
Sorry, I need to make this really clear in my head because I feel this is a really important part of the process and what we're deciding on. So it's 100 people inside, correct? Outside, there is no number. There's been no fire risk involved.
Sorry, no, there is a fire risk assessment as well for outside. That is also 100. They're
Right.
both
Okay.
100.
So it's 100 inside and 100 outside.
But at the moment on the licence, there is no capacity at all for outside. So we could have 200, 300, but the fire risk assessment wouldn't allow us because we could not get them out safely.
Right. Okay. Thank you.
Councillor Abbott, you have no questions? Do you have anything else,
No,
Councillor Penfold? In which case, thank you, Mr. Darcy. And I'd now like to invite Councillor Peter Dickinson to speak.
Chair, Deputy Chair, Councillors, thank you very much indeed for inviting us here today. We're blessed with the good relationship we have with Southampton District Council, and we would just like very briefly to make the point that as a town council and as the residents around that, we do see this as a fundamental change in the use of what has been for the last 20 years a haven of sort of peace and somewhere that the youngest residents and visitors from neighbouring towns have been able to enjoy. We are taking a very proactive view, and we have written, as our friends here know, to Mr. Kevin Georgiall, the CEO of St Austell Brewery, to point out the fact that the removal of the children's play area, which may hopefully is relevant, has alienated and is alienated the largest single group of clients to the pub over the last 20 years, which is the families with small children. And it isn't just the town, it's the neighbouring areas as well. So we fully understand the residents' concerns about what we consider to be a fundamental change of the garden, because there is, even though with all the plans we've heard, it is going to encourage more people outside drinking later in the evening. And even if it does serve alcohol until 9 o'clock, it is reasonable to suspect that people will order a significant amount more alcohol so they can continue drinking, etc. So we effectively are trying our hardest in the best possible way to see how, if the entire town council, the town that we represent, and all the residents, what we can do more to suggest that this is not an appropriate change of use, in our view, of the garden area. What we've also said, and this is perhaps worth bearing in mind, that in our letter to Mr. Georgiall, which our friend here, Gareth James, was given by Mr. Georgiall, we're saying that if they were to revert to the existing or the previous situation, which has been in place since 2005, of the children's safe play area, that those families who've supported it for the last 2 decades or so would continue to support the pub, not just during the summer months, but throughout the year. So please take it as we're taking a very proactive view on this, but we do consider this to be a change in the use of the garden, which is against the residents and the town's wishes. Thank you.
Thank you. I mean, again, the applicant stated, to my understanding, perfectly correctly that the play area is, I mean, it's probably out with our concerns, but that is entirely in their gift. It's their property; they can do with it as they wish. You presumably, as a principle, I agree. You might think it regrettable that they've chosen to do what they've chosen to do, but you have no qualms with the fact that they can remove play areas as they like.
understandably. In my dim and distant past, and I have to stress that I have a degree in planning law, but that is in my dim and distant past, we do appreciate that. And this is why we've taken the two-pronged approach. One is to formally object as a town council to the extension of the licensing. And secondly, taken a separate tack, which is to recommend to the CEO of St Austell Breweries that it would be more commercially sensible and profitable to reinstate the children's play area and reinstate that what was there before, which gave them a significant amount of extra income throughout the year. Thank you.
Thank you. Councillors, Councillor Penfold? No. Well, I think...
Sir, am I able to address the variation point or anything else that my friend said? Because, I mean, he's called into question the whole application.
I think I am content that we will take advice from our legal advisor on that point. Thank you. If our legal advisor is content to provide it.
Probably just was one thing that was incorrect. When you look at the videos, I just ask you to have a look at the two latest ones, which I think are 11:55 and 11:41. There's nobody in those outside areas at that time, so there are timings there. But I would just ask you to have a look at it because the suggestion it was like a circus or something going on in there. That was all, councillors. Thank you.
Thank you. Perhaps do so. In which case, we will now retire. It's easier for us to go away, I think, and let you have the room rather than try to do it the other way around. So we'll go to the members' room. And we will return after due deliberations. We'll try and be as quick as possible. We have another application to get through after all. There is tea and coffee outside, so do feel free to help yourselves. Thank you for your patience, everybody. We've considered today the application to vary a premises licence at the Victoria Inn, Fall Street, Salcombe. We've considered the statement of licensing policy, the government guidance, and our obligations as they relate to the promotion of the licensing objectives. And we've reviewed carefully the written representations we've received from all parties and the additional statements we've heard from the persons here today. It is our decision following that process to grant the application subject to the following changes being incorporated into the operating schedule, namely that the opening time of the outside bar be 12 noon as proffered by the applicant. The reasons for our decision are as follows. We have taken legal advice on the admissibility of the application in response to representations by objectors, and that advice is that this is a valid application under section 34, and we are not convinced that the additional impacts on the 4 licensing objectives caused by this variation relative to those under the existing licence are sufficient to warrant refusal. Thank you. Good morning, everyone. For those of you who weren't present for our first application, welcome. This is a licensing subcommittee meeting of today, 20th of August. Little bit of housekeeping. We've had a fire alarm test this morning, so a fire alarm would probably be the real thing, in which case the doors are those that you came in straight out that way and muster at the far end of the car park. We're live webcasting today, so if I could remind members and other people who are going to speak to turn on their microphones when speaking, that would be useful. Similarly, if I could ask you to turn off or silence your mobile phones, that will again help the meeting proceed. So we're here to consider an application for a new premises licence at Coronation Boathouse, Bantham Quay, Bantham, Kingsbridge, TQ7 3AP. The process will be as follows. In a moment, I'll ask the case officer to present her report. We will then invite the applicant to speak in support of that. Members will be able to ask, after each of these interventions, members will be able to ask questions of the officer and the applicant. We will then invite anybody who wishes to make representations in objection to speak. And likewise, members of the committee will be able to ask questions of them. Once everyone has spoken, the committee, which is myself, Councillor Penfold and Councillor Abbott, will retire to consider our decision. We will be supported in that by our clerk and our legal advisor, and we will then return and we will read out the decision. I would now like to ask the officers at the top table to introduce themselves, and my colleagues indeed. We'll start with you, Catherine, if we may.
Good morning, my name's Catherine Bowen and I'm the Council's legal advisor and also specifically this morning for the licensing subcommittee.
Hello, my name's Amelia Bolter, Senior Democratic Services Officer and Clerk to this committee.
Hello, my name's Sam Penfold. I'm councillor for Malden and Little Hempston, and I'm the deputy chair here.
Hello, I'm Naomi Stacey and I'm the Senior Licensing Officer for South Hams.
Good morning, my name is Harry Leonis. I'm the Licensing Officer at South Hams.
Good morning, I'm Victor Abbott. I'm a ward member for Ivybridge East and I'm a member of this committee.
And my short-term memory's going, but in case I didn't already do so, I'm Simon Rake and I'm the chairman of this committee. Those are the formalities out of the way. The sort of boilerplate part of the agenda has already been discharged. So if I could invite you to present your report, please, Naomi.
Thank you, Chair. So we have received an application for a new premises licence for Coronation Boathouse, Bantham Quay, Bantham. The application is for the supply of alcohol for consumption off the premises Monday to Sunday from 8 AM until 5 PM. A copy of the application form and the licence plan is at Appendix A of your papers. As can be seen, the original application was submitted for the supply of alcohol for consumption both on and off the premises. Following submission of the application, we were contacted by Mrs Fosber on behalf of Bantham Estate to confirm that an error had been made and that she wished to withdraw the supply of alcohol for consumption on the premises, so that alcohol would be for consumption off the premises only. This was accepted at this time and communicated to all the responsible authorities, as well as to any person who made a representation to the application. Another error on the application form, which has been highlighted by one of the objectors, is the box ticked by mistake in section H, which relates to types of entertainment similar to live and recorded music and dance. As the corresponding box was not ticked on page 6 of the form, and no days nor times were included in section H, this was never considered to be part of the application. The premises is described as a two-storey building with the ground floor a boat and wine storage area. It is situated on Bantham Quay and a map of the location is provided at Appendix B. During the consultation period, 3 relevant representations were received in objection to the application and 5 in support of the application, and these are attached at Appendix C. The main concerns in objection to the application relate to the potential for a public nuisance to be caused by the use of the building for the storage of alcohol with subsequent collection and delivery movements within the vicinity, and also concerns about public safety have been raised. To help address concerns raised in the representations, during the consultation period, Mrs. Fosberg confirmed to the licensing department that she would like to restrict public access to the premises and agreed to include a condition that the building would not be open to the public at any time. The only people accessing the building and transporting deliveries will be members of staff. It should be noted that as members of the public will no longer have access to the building, due weight will need to be given to relevance of reasons relating to the public safety of the building itself when considering the application. Representations in support of the application have highlighted the fact that members of the public will not be able to access the building, limiting any concerns related to public nuisance and public safety. It is also mentioned in the representations that access to the quay for collecting or depositing wine would be carried out in the same way as boats currently are transported and any other equipment, and that there is also CCTV in place at the building. Following the conclusion of the consultation period, we received a list of new proposed conditions to address the concerns raised in the application and the representations, which the applicant would like yourselves to consider when making your decision. Those objecting to the application have confirmed that these conditions do not fully address their concerns, and they would not currently be happy to withdraw their representations subject to these conditions being included. Since the publication of my report, we have received some additional information from those in objection and in support to the application, and this information has been circulated to the applicant and to the licensing subcommittee and is listed in the papers. Contained in one of these letters is concern that the sale of alcohol has taken place illegally from the nearby Bantham Estate office. I can confirm that there have recently been 3 temporary event notices in place at the Bantham Estate office to cover 3 launch weeks for the wine, is the description in the temporary event notice. So there were periods of time recently where they were permitted to sell alcohol. Only the police and environmental health are able to object to a temporary event notice application. Another concern that's been raised in the representation is the fact that the application has been amended during the course of the consultation period. This is actually a common practice, often to address concerns that are raised in representations in the hope that we can come to a mutual agreeable conclusion between parties without the need for a licensing subcommittee meeting. Providing any amendments that are proposed reduce the activities being applied for or add more restrictive conditions rather than removing any, there is no need to restart the application process. All changes are recorded in writing, and the premises licence that is produced at the end of the process is then the definitive document that specifies what activities are permitted, the hours of operation, and any conditions that are imposed. As always, any information contained in the representations which is not relevant to the licensable activities applied for and the promotion of the 4 licensing objectives cannot be taken into consideration. This includes previous planning applications, as planning and licensing are 2 separate regimes with their own legislation. All that can be considered today is whether the supply of alcohol for consumption off the premises with no public access to the building can take place from this location. And just as a quick reminder, the licensing objectives are prevention of crime and disorder, public safety, the prevention of public nuisance, and the protection of children from harm. So let me know if you have any questions. Thank you.
Thank you very much. Councillor Penfold? No. Your report was obviously a model of clarity. Thank you, Naomi. So turning to the applicant, we don't impose very strict time limits, but if you could aim for no more than 10 minutes, that we'd appreciate it.
Yes, sir. I'm probably going to be slightly over 10, but I've got some good news. Manon probably will not be speaking unless you wish to hear from her on specifics, because obviously this has been agreed, and the 2 ladies to my left are going to be 5 minutes max. So we should be pretty quick.
Okay. Thank you. Well, I'm not sure whether that's good news or not. We shall see. Thank you. Okay, well, I'll chivvy you along, if I may, if you trespass too far beyond your 10 minutes. But if, as I say, it's a goal rather than a limit. So perhaps you would start, and I won't let this eat into your time, by introducing.
Okay, well, my name is Nick Semper from the Licensing Guys, and we're representing the applicant here today, being Bantham Estates Limited, here in the person of Ms Manon Fosburg. By way of introduction, Bantham Estate Vineyard is a new vineyard of 25,000 vines, planted in 2021 and located in the South Devon natural landscape overlooking the Avon estuary. Manon is the estate and vineyard manager. The purpose of the application is to license the ground floor of the boathouse owned by the estate as a base for an online, telephone and email-based sales operation. As you're aware, it is the location where the alcohol is appropriated to the sale that requires the premises licence. The hours applied for are 8 till 5 at night daily to allow these electronic sales to be processed. However, we will only ever sell our own produce, and our produce is necessarily limited by the size of the vineyard itself. Then sales can never be in full swing from 8 in the morning until 5 at night every day of the year anyway, as the volume of our stock would not support that level of activity. This licence simply seeks to authorise any such electronic sales as and when they occur. Most sales usually take place between June and September each year. However, a small residue of stock is maintained throughout the year. This is, in fact, a de minimis operation, but an essential element in bringing the wine to market, yet it permits no members of the public on site and no on sales. There was some initial confusion on behalf of the applicant, as licensing laws and procedures are very specialised areas of law. I don't need to tell you that, because you, as members of the licensing subcommittee, have already received detailed specialist training to allow you to perform your functions on behalf of the licensing authority. Licensing guys were engaged to clarify matters, and last week amended the original application to be simply off sales 8 till 5 daily, and substituted an amended draft of licence conditions, which is this document here, to be entailed with the application. Those revised conditions ensure the robust promotion of licensing objectives and a safe, legal and compliant operation in every respect. As you'll be aware, each application must be judged on its own facts and merits. The significant merits of this application is it a quality application for a quality operation and a quality product, correctly conditioned with specific, appropriate, proportionate control measures, thus minimising any potential that any of the licensing objectives would ever be undermined. Now, in this hearing, the burden is on the applicant, i.e. me and Manon, to show that the proposed operation supported by that operating schedule is capable of promoting the licensing objectives and is unlikely to undermine them. Any representatives, on the other hand, opposing the application have the burden to show that these premises, trading under this operating schedule before you, will undermine the licensing objectives and demonstrate that with evidence. In our submission, any subcommittee properly advised could only refuse this application if it is found on the evidence of the representatives against the application to be not capable of promoting the licensing objectives. And you may ask yourselves, why do the representatives, aka objectors, need to produce evidence? That answer is found in para 9.43 of section 182 statutory guidance, which clearly states, and I quote, the authority's determination, i.e. your decision here today, should be evidence-based, justified as being appropriate for promotion of licensing objectives and proportionate to what it is intended to achieve. Significantly, there is not a shred of evidence in the comprehensive hearing papers before you which challenges, criticises or even references the operating schedule, the applicant or the designated premises whatsoever. Designated premises supervisor whatsoever. There is absolutely no concern evidenced involving these premises regarding licensable activities or this applicant or any other of their operations before you. That is an undeniable and self-evident fact. So let me first walk you through who has, or rather in this case, who has not raised any representation, aka objection to this application. Firstly, the licensing authority. Those two wonderful people over there, being the lead responsible authority for all licensing matters in South Hams, they've made no representation. The police, being the lead responsible authority for the crime and disorder licensing objective, have made no objection. The planning department, the experts in planning, in this council have made no objection. Trading standards, children's services, the responsible authorities for the protection of children from harm, public health, who safeguard against substance misuse, and of course, environmental health, being the experts in noise and pollution and safety issues, and therefore the lead agency on public nuisance and public safety. They all raised no objections. This hearing is an evidence-based decision-making process. You as a committee cannot be insensible to the fact that not one of the lead and expert responsible authorities has objected to this application or has presented any evidence against it whatsoever. You can therefore rightly assume in my submission that, in the opinion of all the responsible authorities, the operating schedule before you does not undermine the licensing objectives, but in fact actually promotes it. Otherwise, the responsible authorities will be in the room with evidence to argue vehemently against it, as is their statutory duty. We are then left, therefore, with the three public representations. They no doubt come from good people. But we need to think carefully about what they are complaining about and how relevant they are to the current application before you. I will break down the arguments raised in each by heading in turn and deal with each in turn. Firstly, Katie Fryatt believes, she works for Exeter Airport, I believe, and does not live locally. She believes that the building is unsuitable for commercial use and the operation should be located elsewhere, as the access is narrow and steep and the character of the area will be blighted. In her opinion, there are threats to public nuisance and crime disorder in selling alcohol from here, though she does not specify exactly what those crime disorder issues are. Nick Cotter also believes that the location is unsuitable and storing and packing our own modest quantities of alcohol within our own building will cause a public nuisance, and that our use of the lane, that slipway, will cause public safety and public nuisance and a threat to public safety, as will converting the premises into retail and office accommodation. He also believes that delivery vehicles would obstruct the access road. He holds that the hours applied for are excessive and will cause a public nuisance. He claims that the applicant is already selling alcohol unlawfully, and lastly he claims that we have amended the application, the whole application is rendered invalid and insists that we should therefore reapply. The parish council here today have also objected due to history of the building flooding. As such, the public safety of staff and couriers would be endangered. They also complain that there has been no change of use application to made to the planning authority. They describe members of the public using the estuary to relax, and that access to the boathouse via the narrow slipway poses further risks to public safety. Okay, that's a summary, a flyby of what they're complaining about, and I'll break those down each in turn if you will allow me. Public safety, para 2.8 of the section 182 guidance tells us that public safety licensing objective refers to members of the public using the premises for licensable activities. Their physical safety references harms which can result from alcohol consumption. If you have a look, it's para 2.8. But no public are allowed in the boathouse under the terms of this licence, and therefore no members can be endangered. Members of the public can be endangered therein. Neither can the public consume alcohol inside, so they can't be harmed by consumption of alcohol on the premises. Therefore, no risk or element to public safety is entailed by the use of these premises for the uses as applied for. Similarly, as members of the public are simply not allowed on site, let alone drinking on site, how can they be exposed to crime and disorder? They cannot. Public nuisance, para 2.21, again, is really useful. In the section 182 guidance, it states that licensing authorities, your good selves, should focus on the effect of licensable activities at the specific premises on, and I quote, persons living and working in the area, which may be disproportionate and unreasonable. A couple of things on that then. Are the persons, the representatives? I mean, there's Katie who lives, I haven't got a precise address, but I understand she lives distance away. Nick Cotter, who lives 5.4 miles away, 20-minute drive. Are they affected by the public nuisance? Are they actually living and working in the area? And secondly, is this de minimis operation going to cause such a level of public nuisance as to be disproportionate and unreasonable? The guidance describes such nuisances. They define them. In para 2.1, they give a list of them: noise, light, pollution, noxious smells, and litter. But none of those issues or their like are referred to in any of the public representations. Therefore, I'm not convinced that any of the licensing objectives referred to in the public representations, firstly, especially the first two, are actually engaged anymore following the submission of the revised application and the raft of conditions. And I look to your legal advisor to advise us on that if she deems it helpful. I'll now turn with the issues raised in the public objections themselves. Steep and narrow slipway. Yes, it is a right of way. And it lies across land. It's our right of way. It's our slipway. And it runs across land that we own. No motor vehicles are allowed to go down there without her permission. The wine would be delivered to and from the boathouse by Manitou once a year between May and June. Are we okay? Manon is one of the only 2 Manitou drivers employed on the estate. It takes 4 journeys from the top of the slipway down to the storage, 4 runs by Manitou. That's all we're talking about in a course of 1 year. Small orders of wine can be carried by hand back up the 170-metre track. Larger orders can be brought up the track by the Kawasaki mule, which already runs up and down that track to the harbour on an almost daily basis. If boats and marine equipment, I would ask, can travel up and down that track, well, why not our own vehicles, which already use that track, carrying small quantities of our own wine? Wine is no heavier, hazardous or potentially injurious or nuisance creating to the public than anything else that passes up and down that track to that harbour. As it happens, the quantities we are talking about do not make the use of the path any more or less of a risk to public nuisance or public safety than what is currently occurring at present. Now I'll talk to you about flooding, if I may. Firstly,
before you do, could I ask you to turn your mind at the same time to drawing to a close?
It's really difficult in as much that there's been so much raised by the representatives that to give these people a chance of a fair hearing, to be able to explain and counter the issues raised in simply 10 minutes. I can tell you, sir, that I'm down to just a couple of slides left, and I will speed up even faster than I'm going now, if that helps at all, sir.
Okay, if it helps, we have seen the representations, so you don't need to necessarily recap them for us.
Well, I need to address you on flooding. I need to address you on planning. I need to address you on the fact that, well, if you accept that these people have not been selling alcohol unlawfully, but have been selling it lawfully in accordance with the TENS, that's something I don't need to deal with. I'd like to deal with you. I'd like to address your lawyer, particularly on a stated case, which is Thwaites. And we're on magistrates about fear and speculation, and I'd like to summarise. So I think I'm going to be about another 3 minutes.
Crack on.
Okay. Flooding. Firstly, we believe that the boathouse is not completely flooded in 30 years. The photos provided with the representations before you by the representatives, we believe, come from 1989. Yes, there have been some high tides, but we are aware of them, especially when we are warned of them, and we receive a warning ahead. Secondly, full wine bottles do not float. Any damage to bottles caused by flooding would be negligible and easily sorted by washing the bottles off thereafter. Thirdly, the fact that the boathouse might flood at some undisclosed time in the future and that some of the remaining stock might get wet is of no concern to the representatives, and the prospect itself does not actually speak to any of the licensing objectives. So in our submission, it is an irrelevant consideration per se. We're not going to touch on Mr. Cotter's personal attacks on the applicant, so we're going to deal with planning. Para 14.65 of the Section 182 guidance tells that planning permission, building control and approval and licence regimes will be properly separated. Therefore, planning is not a matter for this committee, okay, which is something that young Naomi mentioned. I'd like to talk to you briefly about fear and speculation, and I'm going quickly. Public representatives speculate that were you to grant this licence, then they fear there may be problems. There are 2 main reasons why fear and speculation are not admissible in these proceedings. Firstly is this. As I've already told you, Para 9.43 to 182 guidance clearly states that your decision must be evidence-based. Fear and speculation about what might or might not happen at some undisclosed point in the future is not evidence. It is what it is. It is fear and speculation. Secondly, there was a ruling in the Daniel Thwaites and Wirral Borough Magistrates Court, in the High Court, I should say, back in 2008, where Her Honour Justice Black handed down a judgment. And in it, I'm not going to go into, I could read it to you, but please, your lawyer can help us, I'm sure. Her judgment indicates that your decision making should be actuated by real and proper evidence. There is no history of problems with this applicant, nothing before you from the responsible authorities, and the potential for any such issues is more than properly addressed in the proposed conditions. That was quick. In any event, if there are problems going forward with the grant of this licence, then you may revert to the statutory remedy, which is the Section 51 review process, which is already provided by Parliament if there are problems upstream. And I honestly assure you there won't be, but I can no easier look into the future than anybody else in this room. Okay, so in summary, this hearing is simply about whether this small pick, pack and dispatch operation operating these hours in accordance with the operating schedule before you, including the comprehensive raft of conditions, will undermine or will it promote the licensing objectives. Very, very clearly our position is that it will, and all the expert responsible authorities raise no objections with its substance, content and additional inbuilt safeguards. There is no recorded history of or indelible evidence of noise nuisance, pollution, safety, ASP, drugs, underage sale or crime and disorder issues with the operation of these premises or indeed any other cause for concern regarding the promotion of the licensing objectives evidence involving this application or this applicant or any other licensable activities they've conducted in South Hams at all. That is an undeniable and self-evident fact. Consequently, I respectfully request that you do indeed grant this application for the premises licence as sought and that you wish Manor and Bantham Estates every success going forwards with their new venture. Thank you very much indeed. Thank you.
Thank you, and thank you for your Herculean efforts to speed up. They're
Can we have that minuted Herculean? That's good.
Councillors, do we have any questions of Mr. Simper?
Just a curiosity, why this building and not another building?
Because it suits the business as it stands. Efforts were made to seek, and I don't want to talk about planning permission for obvious reasons because it's not relevant in here, but efforts were made to seek out other locations on the estate, but they were frustrated in other committees in South Hams. Ma'am.
Just to clarify, so I get the four trips to load the storage area with the wine. In terms of withdrawing it, you're selling to the retail and also wholesale trade. That's your intention.
Yes. So they have AWRS, and they also would like a premises license, so they can sell by retail. You're correct.
And presumably wine will then be shipped on to the final customer via courier.
Yes.
Am I right?
Or could be collected from the top office, seemingly. Yes.
But only when it has been purchased
online. You're absolutely right. It's where the appropriation takes place, where the pick, pack and dispatch operation would be, and that is down in the storage facility, which is Coronation Quay.
So I'm fancying a bit of Bantham wine. I'm down there on the beach. I walk into the main office and say, "Can I buy some wine?" And they say, "Yes, but you'll have to order it on your phone whilst you're stood there, and then we'll bring it up for you." Am I right in thinking that's a possibility?
So I've tried this on the 10, and if people were interested, they would just send me an email or just give me their contact, and either they need to come back on another day, so I make sure I get it ready for them to collect, and if they need to go, then I'll get it sent to them, but they can't collect, just come in and say, "Can I collect?" The 10s did allow me to do this, so I've tried.
Yeah, you're absolutely right. We are not opening an off licence on the beachfront. So you cannot, members of the public cannot walk in there. You cannot walk in there. And no, you cannot buy. Or B, you go through a rigmarole to pretend to buy it on your phone and Apple paying it. That will not happen, sir. So this will not be. Well, there is another business down there that is licensed to sell on the waterside, isn't there?
So the gastrobus is allowed, but that will be for the spritz. And then there's a local shop that will be allowed as well with our AWRS, which we can give to them.
So the scenario that you just came up with will not happen at this location, sir.
Thank you. In the absence of any other questions from my colleagues, in which case I'd like to invite Mrs. Judy Pearce to speak. I understand you're to speak in support of the application. Feel free to avoid anything that has already been raised.
Of course I will. I'll also avoid saying what I've already said in my representations about this being a new business in the area and all the rest of it. The only thing I've really got to say is on the flooding aspect of the building. I know that tidal flooding is considered to be predictable, particularly in an estuary, because this case has been raised many times in Salcombe before. You know when the high tides are going to be. You know which direction which wind direction brings a flooding tide in. And meteorological predictions are now good enough to know when there's going to be a tidal surge if the pressure is particularly low. You would need to add into this, in the case of the Avon, any heavy rain upriver. But there should be enough notice to know when it's likely that the boathouse is going to flood. And I would suggest that for the normal flooding, which you have photos here, that storing the wine on a couple of pallets would be entirely enough at the back of the boathouse for the wine not to be affected. And in exceptional circumstances, you would have at least a couple of hours notice, in which case you could get the Manitou out and actually hoik it out and take it up to the top of the hill where there wouldn't be a problem. So I do think that the flooding argument is probably not a valid detractor from this application. And I would urge the committee to support it.
Thank you very much. Mrs. Williams. Oh, sorry. Excuse me. I was going to take both submissions at once, but if you want to leap in here, Councillor Abbott, you're welcome to leap.
So I'm glad that it's being discussed, because I'm not convinced it's a licensing issue. It just seems to be going there in such a parallel way, and it's not the wine I'm worried about. It's the electronics and the electronics and electricity that I'm worried about.
Well, in my knowledge, there's very little electricity in that building. I think there probably is electric light, but that is about all. And presumably, because there has been flooding in the past, the electricity is organised so that it's up the walls, because that's what you do when you get flooding, isn't it? You don't put cables under the floor or anything.
He wants to know about the electricity in
There's just no there is no electric relevant to the wine storage itself. Like there's no computer or anything like this. It's just like a storage.
No computer on a.
It's literally just like
on an online system.
So it's
the appropriation.
Would you like to answer?
So no, because it's an online system. So we've got either it's on the phone, iZettle, but people would not go down, so they either would pay on an iZettle or they pay online orders. So there is no. It's literally just a storage down there, concrete. Two walls, concrete and wine. There is nothing else at a table.
Thank you. And with your permission, Councillor Abbott, we'll now move on to Mrs. Williams.
My name is Sian Williams and I live at Higher Alnmouth Farm with my husband, whose family have had the farm for 60 years. We're next door to the Bantham Estate and Lower Alnmouth Farm, which is also estate owned. I was a Thurleston Parish Councillor until about 15 months ago, and helped develop the neighbourhood parish plan. I'm in and out of the estate generally every day. I swim in the summer and surf all winter and walk the dog, and so I more or less see or go past Coronation Quay and the river every day. I'm a member of various local water sports groups and local parents' school groups, so I feel I have a good sense of the local community. There are CCTV cameras at the quay, as well as estate employees there every day during working hours, and a nighttime security person on the gate at the beach entrance near the road down to the quay. The boathouse is securely locked and only the mooring manager has a key. This is not an entertainment value, and nor do the community want it to be. There are no drinks being served to the public. Members of the public are not allowed to go inside the boathouse without permission. And although it's old, it's locked and secure at night. In my memory, it's never been broken into. The storage of 3 or 4 pallets of wine has had no effect on public safety, I believe. Quay users walk up and down the road to the quay constantly during the summer, and particularly on high tide. Storage of those pallets has not made any difference to that movement of those pedestrians. The estate has already been selling wine using the temporary licenses granted, and it's been there since May, and to be honest, I did not even notice it was being stored there until about a month ago. There are a few employees, 2 or 3 at the quay, running the ferry and keeping an eye on boat users and swimmers. They're all responsible adults, all former lifeguards, swimmers and sailors. We've known them a very long time, and there is a sense of safety and security when you are down by the estuary, and to be honest, I really couldn't feel any safer when I'm there. If someone wishes to purchase wine, it's by appointment only between 8 and 5, and a member of the estate team will go and get it for them to bring back up to the beach entrance or office. And they can arrange to do this, of course, at less busy times of the day or outside high tides. There's no delivery vehicles going up and down to the quay. Again, there's no consumption on the premises. Also, the delivery of wine by the lorry, as we've heard, will only happen once a year. There's no reason to believe this will cause a nuisance to the public. Orders and collections will be done by appointment. There are no vehicles being driven up and down. There is no serving of wine on the quay. And actually, boat owners do bring their own wine and alcoholic drinks and sit down on the quay for their own private consumption anyway. This has never been an area for any kind of disorder. It's a very small village quay for tranquil activities. Wine being stored in the boathouse has not changed that. We store about 35 to 40 of the boats during the winter that are moored at Bantham up at our farm, and they are all launched up at Averson Gifford now. So there is, in fact, fewer boats being launched and or retrieved at the quay, but that is all done before and after the busy season anyway. It's not caused any harm to children. This is not an entertainment venue or wine shop or liquor store or a place for parties and events. There's no consumption on the premises, and the estate staff are there constantly during the summer, 8 till 5. It's basically had no negative impact on our family or any of our families, friends' families. I've been bringing my own children here for 17 years for boating, crabbing and paddling, and I cannot see how storing a few pallets of wine in the boathouse has made any difference to our friends and other families' activities. You know, members of the public, again, wishing to purchase are not going to be able to access the boathouse, and any vehicle access by the ferry staff or quay manager to launch boats is done very carefully and by arrangement with the boat owners. A wine delivery lorry can't get down there. It's logistically impossible. I've nearly finished. There's no plan to change the bottom of the boathouse to anything else, and if there was, it would have to go through planning, and actually none of the community wants it to be changed to anything else, including me. But there's no reason it can't share some of its space downstairs with boats. 3 pallets takes up about the same space as the ex-harbour master's Toyota that he used to store in there occasionally. And if there's a high tide expected, things can be moved. I've only seen a very high tide once in my life memory since I've lived here. And lastly, from what I understand, it's only a small supply being stored here for local purchase. Most of it's being stored at a central warehouse elsewhere. And given that 50 locals helped to hand-pick those grapes last autumn, myself included, it would be a shame if it couldn't be sold directly from the estate to the local consumer in our community. 80 or so guests were invited to the official wine tasting day in June, and everyone I spoke to want the team to be able to do their job well and safely and efficiently, and to further their business, which could be an important asset to the local economy and community. Thank you very much.
Thank you, Mrs. Williams. I'm getting a bit confused now. Presumably this can easily be solved. The total quantity of or the récolte for a year is what? Because we've had 3 pallets and 4 trips by Manitou and so on.
So my goal is just to have enough quantity at the boathouse for the local community. We work with a winery called Itasca, and they have a massive warehouse. They will be able to distribute to shops and hotel and restaurants. I would like enough wine for the local community, people that would book and are on site, to be able to get a bottle of wine directly from myself, because I get really invested in growing these vines, and I want to be able to hand some bottles to the locals. So everything else is just full, I can say full pallet, because that will be enough for the year last. And then if there is any more needed, Itasca will then divert the wine to the shops, to the restaurants.
Okay, that helps a lot, but confuses me in another area, which is, are you? So I had formed the impression, clearly erroneously, that you were talking about essentially sort of selling wine by the box of 6, and now you're saying you want to hand bottles individually to local people, which seems to contradict the impression I'd formed.
Well, it's just because people may buy 1 or they buy 6 bottles, so it depends of the order I would get. So it's just local community, you know. There may be some heavy drinkers that would like 6 bottles, and there may be some that want 1 bottle.
Can I just stop you 6?
There at least we're in agreement. I mean, all at once, obviously it is, but thank you. Okay, Councillor Abbott?
So I also am confused. Are there bottles being stored in this place already?
Yes, sir, there are. What's the problem with that, sir?
So your application then is for the sale rather than for the storage?
For a pick pack, storage is not a licensable activity, so pick, pack and dispatch operation is.
And then when the quantities are so small, really, why does it need to be there rather than on your other store?
Well, because the other store is some distance away, so there's costs of storing it there and transporting it. This is for people in this part of the counties.
It's in Reading.
I'm sorry?
The other store.
The other store's in Reading, yes, sir. The national distribution.
It will be difficult to hand pick.
I don't understand, sir. The storage is not licensable. They do sell wine under the authority of temporary event notices, rather than to having to.
I think you were asked a question. I don't think Councillor Abbott made any. So, thank you, Councillor Penfold.
So you produce wine, and then you send it to Reading, but you want to keep a few bottles back and store it on this site. Is that correct?
The Reading is the winery, so once the grape are picked, they go to Reading, and then this year was the first harvest, so we only had a very little amount. Last year. This year is the second harvest, so there'll be a bit more bottles, but the extra will stay in Reading, and I will be bringing back the exact quantity that I had this year, just enough to have for the locals. Everything that's too much because the boathouse is small will stay in Reading.
Honestly, the idea of locals, English is not her first language. It sounds like a few people around the village. We're talking about a localised market around this corner of the county. You have to be really, really clear with these guys, because they're getting the impression that it's 1 bottle at a time to local people walking up and down the thing. It really isn't. Okay, it is how many bottles in all?
About 3,000 I would try to keep in the boathouse.
It is the storage of 3,000 bottles in all for a pick, pack and dispatch operation covering Devon. Okay, this corner of Devon, sir. Thank you.
Thank you. Sorry, I mean, we're getting deep into the weeds, and I didn't recognise the need to hear from Councillor Stone. But just before we do move on, how are you distinguishing, if the sales are online, how are you distinguishing customers in Devon from customers outside Devon?
That's easy, sir. It goes on postcode allocation.
So if I'm in, if I'm elsewhere and
sorry, did I say something funny? Sorry,
yes. If I'm elsewhere and order, I'll be referred to the other supplier.
Yeah, the majority of sales from Ithaca, where the wine, the grapes go off and they're turned into wine and they're stored there in bonded warehouses. And the majority of sales from there go from business to business. They go to golf clubs, restaurants, wine clubs, la 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 la. Okay. As concerns people that visit to Devon or locally living people to Devon, whatever would like to water sun, why should it come all the way from Reading when it can just come up the short 170-metre track on the back of the Yamaha mule? It was not Yamaha, sorry, what was it? Kawasaki mules, there we go. Thank you.
Okay, so we have Councillor Stone speaking on behalf of the Parish Council and or Thurleston Parish Council and Save Bantham.
Hello, thanks very much. Well, I don't know about you, but I'm horribly confused now. I don't quite know what is going on here. This has been a very confusing application, which has changed completely from the first version submitted on the 6th of July this year, which now appears to have been somewhat misleading. Comments were made by the applicant that incorrect information regarding the application has been broadcast on social media. However, it should be noted that those comments were not misleading at the time, as they were responding to what the application actually said. Terms that had been submitted by the applicant, and subsequently these terms have been amended and removed, but the letters of objection have not, and there are still legitimate concerns regarding this application. We understand, taking into account all the changes that have now been made, that we are being asked to license a distribution hub for the storage, packing and dispatch of wine for online sales. That's what it seems to come down to. Amendments have now been made on the application, quite rightly, removing on sales and public access and collections. So we assume, as a result of the extent of flooding that happened on the site being evidenced, and in an attempt to reduce the public safety risks. Although the application form itself has not been corrected, we understand the changes have been agreed between the applicant and the licensing officer via emails, and this is the position today. Although perhaps not directly relevant to this committee, the applicant's consultants, the licensing guys and the applicant state that no change of use is needed to enable the pick, pack and dispatch of alcohol to take place here, as the building has been used for storage since the 1930s. I'm sure you're aware that that is in fact wrong, as a distribution hub for online sales requires B8 use permission, which the building does not have. And it is unfortunate that wine sales are and have been taking place from the building for several weeks without that correct planning permission being in place. However, the implication in all of the discussions is that the building is, because of its name, is still being used as a boathouse. But it's not. It's currently stands empty. I think there are 2 or 3 boats in there. It's not used for storage. It used to house all the boats that have just been noted and now housed at Higher Ormouth Farm, but that's another matter. Quite simply, this building floods. The licensing officer has pointed out that in this scenario, their concerns, or they would consider the flooding in 3 ways: the likelihood of flooding, the frequency of flooding, and the impact of those floods on the building. So the likelihood of flooding: the building is a mere metre from the water on the Avon estuary. Spring tides every month and high tides every 12 hours. Linked with the unpredictable nature of our weather means that predicting when weather patterns will collide is actually almost impossible. But when it occurs, there is no way of stopping it. The likelihood of this building flooding over any others on the Bantham estate is not a question of if, but simply when. Frequency of flooding: potentially this can occur on a spring tide, the severity of which depends on those unpredictable weather conditions. Huge tidal surges have increased in recent years, and due to climate change are set to increase further in the future. The impact of flooding: as evidenced in our response to this application and acknowledged by the applicant in previous planning applications, Coronation Boathouse floods when severe weather patterns occur and can have up to 1.5 or 2 metres of water entering the building. When this happens, it is devastating. The photographs submitted in our response to the application show the extent of the flooding when severe wind and weather conditions occur, with high spring tides, and the sheer force and volume of the water in that instance actually lifted the doors off the boathouse, took them inside to the back of the room. There's nothing that can be done about that. On that occasion, as I say, it lifted the doors off. Fortunately, at that time, the boathouse was being used for its intended purpose, with only boats inside, and boats float. Lesser flooding occurs frequently throughout the year when staff and wine could find themselves ankle deep in water, whilst further upriver during previous tidal surges. That although the photograph or the quote was that the last big flood was 30 years ago, a boathouse further up the river was actually disappeared during a more recent storm, and much damage was done in the river. So this is a distribution in a boathouse on a quay, a distribution centre on a boathouse on a quay. So it must raise some safety concerns. Then we come to, we have to also take into account public nuisance with the increased movement of traffic, and there will be an increase in the movement of traffic up and down the slipway, which is in effect what the track is described. It's a slipway. It's there for boats and boat owners to access the water. There is a slight kind of question mark as well, because very clearly it was stated that the estate owned that road. There is a big question mark over that. It is not necessarily owned by the estate. However, that's an aside. So we also then move on to climate change. The current climate change emergency and our concerns regarding the safety of this building related to flooding are supported by the Devon, Cornwall and Isles of Scilly Climate Impacts Group in their 2001 report, which states the effects of global climate change, and I quote, "Climate change is already having visible effects on the world. The Earth is warming, rainfall patterns are changing, and sea levels are rising. These changes can increase the risk of heat waves, floods, droughts, and fires." And I think we're all aware of what is happening with climate change. And then there's the question of mitigating those issues, the mitigations regarding public safety related to this building. Reference is made to the current fire risk, confirming the fire risk assessment will be maintained on the premises and produced for inspection on request of an officer of any responsible authority. However, the building is in floodplain 3, and as said before, no more than a metre from the Avon estuary, and to date we're not aware of any proposals as to how the applicant intends to mitigate flood risk in such a vulnerable position. Due to the unpredictable nature of weather and climate change, we can only assume this is because managing the impact of flooding here is impossible. Regardless of the quantity of wine produced by the vineyard, the logistics and flooding potential of this building make it impossible to manage the storage of anything other than boats. In fact, Bantham Estate themselves cited the flooding issues in their previous planning application for the new Estate and Harbour Office, where they said, contrary to suggestion, the Coronation Boathouse was unfortunately not suitable for conversion to the proposed office use due to flooding and access issues. Now, the suggestion of moving the wine upstairs to avoid the floods does not solve the access and exit problems when the building floods. But in addition, so users confirmed by the applicant now is that the access to this building, the sale of wines will be busiest during the summer months. I think you said between May and September, which coincides with the additional usage of the quay and the huge increase in numbers of people going down to the quay with their boats and using the estuary and wanting to access the estuary. So the volume of movement on that single file slipway will increase. So and we've heard as well, everyone here seems to be dumbing down the business and saying it's only going to be about 3 or 4 pallets. In the community, we support the vineyard development and we see it as a potential new business and hope that it will grow. It will therefore outgrow Coronation Boathouse as a storage facility very quickly and potentially as soon as next year, should they have a good crop. And they will need bigger premises with better access, leaving the boathouse potentially empty but licensed. And this is not an application for a temporary licence. This is for permanent licensing on those premises. So not licensing Coronation Boathouse will not inhibit the growth of this enterprise, as other more suitable buildings exist on the estate that do not flood, have better access, and are large enough to allow the enterprise to grow. So our only question is, why would you choose a building that floods to store anything other than boats in it? And that is a difficult question for us to answer. So that we believe that the reasons stated substantiate our objection to the licensing application, and we ask that it be refused.
Thank you. I suppose my question is, if the building floods when there's wine in it, so what?
Well, that could be the answer, but I'm assuming that the wine will be on pallets in boxes when it comes from the distribution centre in Reading. It will be very messy. It will not. It means that what you forget is that when the building floods, the water goes away, but it leaves everything it's brought in with it from the river. So it's not, it's not going to be clean and tidy when the water goes down. So
with respect, I don't forget that at all.
I'm sorry. I'm not trying to teach you to suck eggs.
It's
just, I appreciate that, but it will bring other debris in with it.
I suppose my question is, in terms of the licensing objectives, if it floods, we're not suggesting that that's going to harm children or cause a public nuisance or endanger public safety or create crime and disorder. I mean, none of those. It would be the estate's lookout if their stock is damaged.
Yes, I suppose you're right. Yeah, I can't argue that with that. It just seems crazy if you're trying to develop a business and the licensing of that building is to help a business that needs to be licensed to develop. To put it in a building that is potentially going to flood on a regular basis doesn't really seem to make a great deal of sense, but that's really our point.
Thank you. No. It's a simple there. That's had to do a short answer. Councillor Penfold.
With the actual best respect,
Yes.
I think if it floods, and I can understand your logic, completely understand your logic, it's the lookout of them if their product is ruined because of it. But I want to come back to why this building, because for many reasons it doesn't seem the most, hold on, let me finish my argument first. Yeah, sure. Very appropriate building to house this wine in. And you said, I asked you, I have no history with the Bantham estate at all. I'm coming to it completely with fresh eyes, so I want to make that very clear. Yes. So you have a Bantham estate, you have other properties on the estate. So, and you said that you tried to get storage somewhere else on the estate, but it was complicated. No, I don't need to go into the other. But were those applications tied up with other things that you wanted to do when you applied for storage of your local wine?
I just want to answer because I'm the one that I don't want to get involved with the previous planning or anything. At the current situation as today, at the building available at Bantham, we've got a cattle barn, which is not secure, and we've got another building which is not secure. And I did temperature recording, I did assessment of the safety of the wine where it would be. There is no other building as today with the wine arriving that was available to me to put the wine in, unless I was allowed to put wine in the cattle barn, which I wish I could have done. Maybe it would have been easier to me because that's been a very big mess. It's just there is no place as of today where the wine would be able to be securely stored, safety for the temperature that has to be at the right temperature, and that is available, which I can get a pallet, so it needs to be a right flooring to get a pallet truck moving. So this is the situation today.
Okay. Thank you. Do you have any questions for Councillor Stone? Councillor Penfold?
No.
Okay. Councillor Abbott?
I don't.
Okay. In which case, I think, were you intending to speak?
I just wanted to say that there hasn't been very much operational procedure.
Yes, if you yes, I mean, so.
Sorry, I'm Rosa Lewis and I'm the chair of Felston Parish Council, and thank you for inviting me up. What has become very clear to me sitting listening is that there seems to have been not a lot of thought or operational procedure put into place to manage the first harvest of the vineyard, and that the vineyard seems to have been left scrabbling as to where to house and how to distribute their wine. I think to have, I'll be very brief, to have chosen the boathouse as a distribution centre seems an inappropriate choice to me. And I'm very sorry there aren't any better alternatives. The harbour office, I mean, the quantities we're being told about are so small, which is wonderful. I mean, we hope it doesn't stay that way, but are so small, I can't imagine you couldn't have found somewhere in the harbour office or some other building on a 700-acre estate. I just wish there'd have been more thought put into the strategy of managing this operationally from the start, which doesn't really fill me with too much hope as how it will be managed efficiently going forward. And that's all really I wanted to say. And thank you for giving the opportunity.
Thank you very much. Oh, you're leaving before we can ask you questions. But no, it's fine. I don't have any questions. You're not. Councillor Abbott, Councillor Penfield? No, you just said thank you. Okay, I think we have covered the ground fairly comprehensively. I think that we will therefore now retire. It's easier for us to go away and leave you the room than it is for you to go away. So we'll do that, and we'll be back as quickly as we can. But obviously, we want to make sure that we consider the issues thoroughly. And so, yeah, we'll be back shortly. Thank you for your patience. We have considered the application for a new premises licence at Coronation Boathouse, Bentham Quay, Bentham, for the sale of alcohol consumption off the premises. We've considered the statement of licensing policy, the government guidance, and our obligations that relate to the promotion of the licensing objectives. We have read carefully the written representatives from all parties and listened carefully to the additional statements we have heard from persons here today. After this process, it is our decision to grant the application subject to the following changes being incorporated into the operating schedule, notably that the additional conditions submitted by the applicant be included in that schedule. The reasons for this decision are that we believe that the 4 licensing objectives are met by this application. Thank you.
Thank you.
No, you can stand up. So thank you for your time, members and officers, and I'll bring this meeting to a close with a bang of my gavel.